We saw oral arguments today at the Supreme Court of the United States in Vanderstok v. Garland. This is a challenge to the ATF rule from 2022 regulating firearms kits and parts. Let's talk about it. Hey everybody, welcome back to the channel today. That is right, we've got another profound case being heard by the Supreme Court today. That is Vanderstok v. Garland. To talk us through that today, we have brought back founding partner of Michel & Associates. He is also the president of CRPA. That is Chuck Michel. Chuck, thanks for being with us today.
Always a pleasure, guys. Thanks for having me.
Absolutely. But before we get into it today, guys, please be sure to like, share, and subscribe to these videos. It really helps with the algorithms to push this message out as far as it can possibly go. Of course, our objective here is to educate as many people as we can so that the Second Amendment can be a priority when we're going to the ballot box to get those politicians in office that will preserve our Second Amendment rights, thereby preserving all the others. So, Chuck, let's jump into this here. We've got Vanderstok v. Garland. It's not exactly a case that we have been following at the lower courts, but it is now heard oral arguments today at the Supreme Court. This is a case challenging an ATF rule that is looking to regulate what they call ghost guns. Perhaps we can get into that definition here in a little bit, but this was a rule that was made by the ATF in 2022, interpreting the 1968 Gun Control Act to include things like firearms kits, 80% parts kits that can be made into firearms. It was rejected by both the Texas Federal District Court as well as the Fifth Circuit Court. So here we are here in the Supreme Court as it's been appealed again. So before we actually get into what happened at the oral arguments, I'm curious, can you just give me a definition of what a ghost gun, or at least what they call a ghost gun, is?
Remember, commercially manufactured firearms have to have a serial number, and the manufacturer needs to keep track of that serial number, and the serial number, since 1968 anyway, but none before that, the serial number goes with the gun so that they can trace them. But we've always had a long history of people being able to make their own firearms. And if you made your own firearms, you didn't need to put a serial number on it. Certain manufacturers, not necessarily licensed firearm manufacturers, because if the products that they're selling are not firearms, as that term is defined, then they don't need a firearm manufacturer's license or a retailer's license. So certain companies started selling what I would call precursor receivers. They're not fully developed. You can't just pop a barrel on it and put a trigger group in it. It needs more work before it will actually hold those parts and function as a firearm. So the guns that came out that way, the gun ban lobby started calling them ghost guns, because it's another emotion-laden buzzword that they can use to demonize a certain product and scare people about that product. And it became very political. De Leon was famous for having a press conference talking about this is a ghost gun and how we need to stop it. And so ATF, in response to some of that, rewrote their regulation defining what a firearm is, so that many of those products, some of which were sold in kits, so that it came with a jig and the parts, and it didn't take as much as it had historically taken to convert the block of metal or polymer or whatever it may be into an actual frame that will hold the associated parts that go with the firearm. That's what got everybody's attention, is because it got too easy. In the past, making your own firearm meant you had to machine from basically a block of metal the part into a receiver or a frame. Now, with these kits, it became easier and took less time. And that's what freaked everybody out. And that's why ATF rewrote definition so that if it was readily convertible from a block of metal or one of these parts to a functioning receiver, then it would be considered a firearm in and of itself, whereas before it had not been.
Yeah, I guess, it's the foundation that I'm kind of thinking about here when we talk about arguing politically, on the Second Amendment. Things get grouped together, and that's why I think it's good to point out what these definitions actually are when we're talking about how they report, quote end quote gun violence. They include suicides, they include homicides, they include accidental shootings. I feel like this term ghost guns, they kind of do the exact same thing. What they're talking about seemingly specifically in this lawsuit is privately made firearms that don't have a serial number, because when the parts are sold, it's not actually a firearm. But if you're going to define a ghost gun as an unserialized firearm, there's many different ways you can acquire a firearm without a serial number on it, and none of those ways have to do with privately making your own firearm. So when they're bringing up statistics on, crimes going through the roof, you need to understand these aren't just this specific subset that they're trying to address in the rule. It's a very shaky foundation from the start as far as the ATF creating this rule is concerned. And I think that's definitely worth pointing out. So, I mean, kind of with...
Because a lot of criminals will scrape the serial number off the firearm so that it can't be traced. But that didn't stop the politicians from issuing press releases about how serious a problem ghost guns are, And the problem is that some of these folks that were selling these things really did make it so easy that they were bound to have attention called to themselves. And that's why New York and California sued all these companies for unfair, unlawful business practices for selling their products, which the ATF had, until it rewrote the rule, said were legal.
Right. So I guess with that kind of shaky foundation from the start, something else that we've kind of talked about as we've watched court cases go through oral arguments is that the entirety of the case isn't necessarily always addressed in oral arguments. We heard some specific points that the justices were trying to get answers for in this oral argument, but can you broadly just kind of explain what the plaintiffs, Vanderstok, is arguing for here in their complaint?
Well, so this is a facial challenge. They don't have any specific product that they're saying this is not a firearm. This kit, this precursor receiver is not a fully formed receiver, and it doesn't qualify as readily convertible to a fully formed receiver. They're challenging the ATF's authority to rewrite the rule that they rewrote and classify, thousands and thousands of new products as firearms, which then trigger all of the regulations that apply to firearms, like a serial number, but much more than that: waiting periods, background checks, whatever regulations may kick in any given state over the manufacturer's sale of a firearm. They didn't have to do that. So the plaintiffs say that the ATF doesn't have the authority to rewrite the law like this, particularly after they've told everybody that things were legal for years. And this may implicate sort of the Chevron deference case that got rid of agency discretion to kind of reinterpret the law. The question is, is this something that if some new product comes along that people perceive as a problem, or a segment of the people perceive as a problem, what's the remedy? Do you go to the regulatory agency, put political pressure on it like was done here, and then they redefine the regulations through administrative action rather than going to Congress and having to get a law passed, or a new law passed to cover the new product? And generally, it should always be that Congress does this, because agencies will always take advantage. They never err on the side of caution in favor of the people or the consumer. They always defer to giving an agency more power. So the underlying argument here isn't about any one specific product, because there were a number of different types of these precursor receivers and kits available to purchase from different companies. It's about whether or not this regulation is illegal or unconstitutional on its face, because the ATF didn't have the authority to write this because it doesn't comply with the intent and language of the actual statute that this regulation is based on and is interpreting.
Well, we saw Justice Jackson basically outright ask the government attorney, should we be picking parts to deem legal or illegal? She then went on in the same sentiment to ask the plaintiff's counsel whether or not the court should just choose one of the three options that they brought forth as a way to remedy this situation. I'm sort of curious, as she seems to be really honing in on asking questions about what the court should do. Is there a standard here as far as the plaintiffs are concerned? Because when she asked the plaintiff's attorney whether or not they should just take one of the three things that they put forth, his answer was, our only burden here is to prove that the rule is wrong. So are there different standards with which, you bring forth a complaint and it's viewed by the court?
Well, yes, I guess it's the short answer. I don't want to split hairs on standards of review and those kinds of things, but there are different steps, different levels. And when you challenge a statute, it's not your job to fix it. It's your job to point out why it's illegal or unconstitutional. And that's what I think the plaintiff's lawyer was pointing out. But that said, as a practical matter, you usually have to come up with some alternative, the right way to go about it, your suggestion on how it should be gone about. And the government is arguing that readily convertible means quick, easy, and efficient. And that's not in the statute. But the plaintiff's lawyer is arguing that what should be applied is a critical machining operations test, meaning if you have to machine the part, do something that makes some kind of a big difference in the form of the part, then that's not a firearm, not a frame or receiver, because until that critical machining is done. The ATF wants a much lower standard. They want to say, unless it takes 8 hours of work, and you have to do a heck of a lot more to it than put a couple holes in it and shave off some excess parts, then it's unless it takes that much work, then anything less than that much work is still going to be considered a firearm, even though it's not capable of functioning that way because it is readily convertible or readily converted to a functioning frame. So it's a matter of degree. It's like the argument, they're really arguing over how much work is it going to take to turn a frame into a precursor frame into a functional frame that can be used to assemble a firearm.
Well, you mentioned the destruction of the Chevron Doctrine a little bit earlier. I'm curious, how much weight do you think that has on the decision-making of the Supreme Court in this case?
I'm not sure if it will play in here or not. It should, in my opinion, because they are trying to decide whether or not the agency's opinion on what they are allowed to do by virtue of the language of the statute is correct. But again, this is a facial challenge, and this is like Rahimi. With a facial challenge, unless the agency's authority is unconstitutional in every application, as a facial versus an as-applied case. So if they had there may be circumstances where they're going to put another particular precursor receiver up there and say, this takes an hour to convert. And then there'll be another one, and this takes 2 hours to convert. And then there's another one, this takes 3 hours to convert. At what point, how long does it have to take, or how short can it be before it qualifies as a firearm and is regulated as such? And that's not something, they don't have to get into exactly how much time should be required for a conversion to take before it's not considered to be a firearm. They could just say, well, there are circumstances, there are products out there that don't require much work, so this regulation is not illegal.
I'm also sort of curious, it's hard, you're not supposed to do this, but it's hard not to just sort of formulate an opinion on the way that the room is as you're watching or listening to something like an oral argument. Again, we've gone over this Oral arguments are not meant to encapsulate the entirety of a lawsuit or a complaint. They are very specifically meant to answer questions that the justices have on all the stuff that they've already written, read, or made their decision on. But I'm still sort of curious what your thoughts are on how the oral arguments went for the plaintiffs and kind of capturing the room.
Well, I mean, I think that some of these kits, frankly, went a bridge too far. They're too easy. And I mean, I'm not saying from my perspective, I think some of the judges, even the conservative judges, are going to say some of these kits just make it too easy. So they're going to, I think this is probably going to be a loss. The question is going to be, how do they go out of their way to preserve some degree, some allowance for homemade firearms for manufacturing your own firearm? I mean, it is artistic. The homemade firearms, it's a craft. You know, it's like working on a classic car or something, or building something that, you know, it's craftsmanship. And so that's why it's always been recognized as a legitimate thing to do, build your own firearm. But this was one of the points that the plaintiffs' counsel raised, that you're jeopardizing that. You're taking away this ability for people to be involved in that craft, and you're basically trying to turn it all over to commercial manufacturers, which the law does not require. So there's some balances that they're going to have to address here to try and figure out how to protect homemade firearm makers, you know, home gunsmiths, versus kits that they may view as too easily to convert to a functional firearm, and so people with less skills. But you know, even the kits, it's there's still a lot of craftsmanship involved, even in putting these kits together. Because just assembling a firearm is not something that everyone can do easily. So, like as I said, they're going to try. I'm not sure how bright of a line they're going to try and draw, because they can beg off on that by just saying it's an as-applied challenge. I mean, it's a facial challenge, so the law will apply legally under some set of circumstances. And that's what they did in Rahimi to avoid getting into a broader finding. But keep in mind, this is mostly an administrative law challenge case. It's not per se Second Amendment case. This is about what the law says and whether or not an administrative agency has interpreted what the statutory law says correctly and expanded it, but still remain within the scope of the statute.
Well, let's say that you know, the Supreme Court ends up doing the same thing that the Fifth Circuit and the Texas Federal District Court ended up doing, in saying that the ATF overstepped here. Or I guess you can argue for both sides of the aisle here. I'm just sort of curious, how do you see this playing out? Does it have any effect immediately or potentially in the future here in the state of California?
Well, the big sellers of these kits have stopped selling them in California and in other states. So there's not really the same market for these anymore. So I'm not sure. It just clarifies some things, but these manufacturers have basically been largely driven out of business in most states by the lawsuits that were brought against them. And by the way, just so you understand that this is a political issue, the Everytown Law Group, Bloomberg's lawyers, were co-counsel with the California Department of Justice in this lawsuit that was brought against the makers of these kits and precursor receivers in California. So the people who are advocating to have the kits banned politically are now jumping on board with the DOJ, California DOJ, supposedly an objective interpreter of the law. You know, you just see how you talk about weaponization of the law. Now you've got the policy drivers in bed with the law enforcement agency to try and accomplish a political goal, which they largely have accomplished by just costing the manufacturers so much to defend themselves and threatening them with large fines for each of these products that they sell. So they've dropped out of a lot of markets.
Well, having said that, it's still something that we are going to continue following. You see a lot of good precedents set by the Supreme Court of the United States in some of these Second Amendment cases. So we're going to keep following along. Chuck, I'm curious, what are your final thoughts? I know that there's no framework for a schedule as far as an opinion coming out or anything, but do you see this case getting an opinion dropped sooner rather than later?
I don't think this is as controversial as some of the bigger cases they may have this session. I'm not sure. Typically on the biggest cases, they wait until June, like the last day of their session, to drop the ruling. I'm not sure that this is that big of a case to them. They may issue it sooner, and that could be a couple of months. But if they do perceive it as a big case, it would be the end of June, at the last day or two of the Supreme Court session.
Well, I know that we definitely got a lot going on in California here. I know you're a busy guy, so I want to thank you for coming on and giving us your perspective on this.
Yeah, stay informed. Subscribe at CRPA.org. You'll get updates on all the cases that we have in process and everything that's going on nationally. Jump on Second Amendment Law Center, 2ALC.org, to see what we're doing all across the country in cases, Second Amendment cases primarily, but also these type of administrative law cases and First Amendment cases. You know, they want to ban gun shows. That's a First Amendment issue primarily. So they're coming at us with everything they have because there's a certain percentage of politicians who really don't want civilians to be able to own guns at all. And they're going to get as close to that goal as they can until the Constitution stops them.
Well, absolutely. So thank you again. I do appreciate you coming on as always. And guys, if you like videos like this and you want to see more, please be sure and like, share, and subscribe to the videos. It really helps with the algorithms, and it allows you to come on this journey with us as we continue to reshape Second Amendment laws here in California. Thanks again, guys, and we'll see you on the next one.